That is going to be my submission. Shroor Mat said you cannot substantially decrease a person's right. Is this substantial or is it not substantial? That's the first question. Second, Devaru, my mistake, Devaru. Devaru, in the process of harmonization, they said substantial injury you cannot make to a person's right under 25(1). So you will have to answer the question. Is this or is it not a substantial injury? And my next submission is going to be, any violation of equality is a substantial deprivation of the right under 25(1). Very clearly. Any denial of equality is substantial injury within the meaning of 25(1). You have to decide the question, since you're sitting in a group of 9. Is equality a basic feature of the Constitution or not? And if it is, what does it mean? Will you use the provisions of Part 3 to interpret the width, breadth, and content of my right under 25(1)? My argument is, I'm being denied my right under 25(1). Now, my Lord, let me proceed further. What happened is, after the judgment was declared, these 2 women went to Sabarimala for darshan. For want of a better word, in English, you would call it worship. They went. When they came out, the Tantri did a Shuddhikaran. I filed a petition in this court. Mind you, this is when the judgment was in full force and effect. I went. These are the only 2 women who succeeded in climbing up and doing darshan. No one else has succeeded since then. Why? Because the state has not cooperated with us. They refused to give protection for going up. I filed a petition in this court, and in which I put all these facts on record.
Are they devotees, and from which state they are?
Kerala. They are both from Kerala. One's name is Bindu, the other person's name is Kanaka Durga. Both are Hindus. What happened to that petition I filed? I want to.
Attempted to go to the temple prior to the judgment.
No.
Are they devotees or not?
I beg you, let me tell you the facts before I answer that question. As far as Bindu is concerned, she has been taken to the temple by her mother. That is her statement in a petition filed in this court. When she was age 11, she has already been there. After that, this judgment came. After the judgment, only once she has succeeded in going there. Not twice, not thrice, not 4 times. She was mob lynched for having gone there. Kanaka Durga, I believe she had problems with her family members. Her family also kind of came down heavily on her that why did you do this, etc. But as far as the first petitioner is concerned, she was left free by her family to go according to her conscience. But after that, she has not succeeded in going there. In fact, to be honest with you, she has had to migrate out of Kerala. Never mind, that's just a little fact I wanted to let you know. But at the present moment, she cannot live in Kerala anymore. And actually, once she had approached me and told me she's going to migrate out of the country, I said, no, don't do that. Come to Delhi, do what you want to do, but don't migrate out of the country. She also happens to be a lawyer. And
why do you say it softly?
Because she went in her capacity as a, because, well, never mind. It's, I want to tell you just a small little story.
Wrong, as Mr. Sir put it, Charles, lawyer is a social engineer, social reformer. Obviously, she has done her part as a lawyer also.
Yes, because I did not want to say she went there because she's a lawyer. She went there because her conscience told her to go there. That's the point I'm making. Anyway, my lord, never mind, my lord, it's a very emotional issue, what she's doing and what she's not doing. But I want to tell you just a small story to lighten the mood a little bit. Mr. Abhishek Singhvi was sitting next to me, said he was going to give me an award I said, why do you want to give me an award? He said, for not interfering with anybody's arguments. I said, yes, I did not interfere with anybody's arguments despite grave and sudden provocation. So, my lord, as soon as this hearing is over, I'm going to claim my award from him. My lord, I think that the facts of this case that I'm presenting before you are very significant for the outcome of.
We are expecting the other side also to compete for that very award.
My lord,
It
I said
may-
I
it's,
was provocation,
it may
but
not-
never
it
mind.
may not- it may-
Although grave and sudden provocation is a defense, my lord. But never mind about that. I kept my mouth shut like a dormouse. But
Don't say sudden, you can say sustained.
anyway, my lord, to come back to the propositions. So, my lord, what is it that this court has, one more light piece of factual information before I proceed? My lord, the Constituent Assembly debated Article 25 and 26 for a total sum of 4 days. That's all. We are now in our 10th day. So, my lord, really, we seem to be sitting here as a Constituent Assembly. To me, it looks like that. We're sitting here to complete the job which the Constituent Assembly left incomplete. Supposedly, because of my learned friends, 55 council on the other side are telling you that they didn't do their job. Okay. Secondly, they're asking you to overrule both Shirur Math and Devaru. Now, first of all, sitting in this reference, you cannot overrule any judgment. Let me make it very clear. A judgment of a court can be overruled in accordance with procedure prescribed by law. And the procedure prescribed by law is review, curative, and show the per incurium in it. To the best of my knowledge, no one has been able to say these judgments are per incurium. No one used that word throughout these 10 days.
Saying we can definitely declare the law different from what is perceived to be the ratio of
Yes.
those judgments.
What will
We won't decide the case and
Yes.
overrule the result.
Yes.
But we can declare the law at variance to what is understood.
Yes, my lord, I don't dispute your jurisdiction. I don't dispute your jurisdiction, but I will dispute the binding effect of that. I will dispute that.
Definitely.
It will be an opinion.
There's a distinction between the binding effect of a ratio and the conclusion binding parties by way of res judicata. We are not going
We're not res
determine
judicata.
any, but we can always interpret the interplay of 25,
Yes.
26, and the impact of the triangular rights
Yes.
in relation to the freedom of religion
Yes.
in a manner
Which is different.
from what
Yes.
Baru understood
I-
or what Sheshamal understood in
Yes, my
respect
lord.
of Acharaka.
I agree with that respectfully. However, I will dispute the binding value of that because you have not taken this decision in a cause which came before you. I use the word cause, I'm taking it from Article 145 of the Constitution of India, where you have to constitute a bench of 5 judges in a cause. And Justice Nagaratna has been reminding me again and again, how do you bring an issue to court? You bring an issue when you have a cause of action. This bench doesn't have a cause of action.
What you are reopening now has already been decided by the bench presided by the former Chief Justice as to whether a decision on Article 142 can be independently referred in terms of the rules of the Supreme Court rules.
My lord, I
Now,
agree.
that is a hiatus to the form in which reference is made. Once the reference form has been decided,
Yeah.
we will decide the reference on substance that
Yes.
it merits.
Well, Lord, I will address you on substance and merit. I'm not running away from that. And my question is only what is the nature of the opinion that you will deliver? Is it going to bind pending proceedings in this court? That's the issue. I would like that question to be answered. And in my opinion,
See, pending proceedings later on will be decided in juxtaposition to the law that we would be declaring.
What is the effect of this?
yes, well, Lord, I agree. I agree. But what I'm saying, perhaps in answer to my Lord, I'm saying that there can be no abstract answer to that. Well, Lord, I was told by one of my juniors that the challenge to the Karnataka Religious and Charitable Endowment Act hearing was completed before a bench presided over by Justice Narasimha. And I'm told that the judges have de-reserved that judgment, waiting for this outcome of this. Yes. Even that, I'm not making any comment on it. It is their privilege to do what they want to do. They could have gone ahead and declared it. There would have been no violation of any provision of the Constitution. Maybe impropriety, that's a different issue altogether. It was left to their conscience to do what they wanted to do. But it doesn't answer the question, what is the binding character of an opinion that will be declared by a bench of 9 judges, notwithstanding pursuant to 142 on.
You can raise this after reference is ordered. Once we order decide the reference, then probably when a review comes, whatever the subject to order to be passed, you can raise it in that.
Well, maybe I'll have to raise it case to case when any case comes, but I am just warning. It's again a note of caution, nothing more than that. It's just to tell you that whatever you say in this case is going to decide not only the cases which are before you, but also the cases which are not before you. The anti-conversion law, my lord, is pending before a bench of 3 judges right now on a daily basis. It will conclude that issue. So there are many, many issues which you cannot anticipate, which will be covered by your opinion. And that is why I'm only sounding a note of caution. And we need not preempt all those issues. Obviously, I will address you on the merits. There's no question about it. I have to make good the submissions I have started with in my opening arguments. So, my lord, let me come back. It's only this. Only just keep it in the back of your mind that you're not only deciding Parsi women's entry, this Bindu's entry, or FGM. FGM is before you, which there's going to be no decision. Can you genetically mutilate a Muslim woman and say that it's part of the right to religion? Question is there before you. So these are not the only questions before you. There are also questions, you will have to deal with Article 21 in that case. And then there are also questions which are not before you. One example I gave you is anti-conversion. Some 20 petitions are pending in this court, all challenged. A question was raised by one of you, my lord. What about UCC? Will you be in a position to challenge it or not? And a very unsatisfactory, in my opinion, answer was given. You can do that, but you can't do this. That was the only answer given. That a specific question was raised. If Mr. Vaidyanathan's argument is correct, will this country be able to bring in a UCC? Answer is no, if you accept his arguments. Autonomy. Well, Lord, some of the council have been economical with the truth before you. They've argued one thing for one religion, another thing for another religion. I believe that all of us are amicus before you, and we need to be not holding a brief, but assisting you in how you can decide this question. But this is what has been going on for the last 10 days. And I can give you specific examples of how the same person's argument changed while dealing with one religion and another religion. Never mind, but keep it in mind while deciding. Somebody, I think it was Dhawan, who said 26 is about autonomy. Did he spell out what is the meaning of autonomy? Did he say that? Did he say whether an exercise of the right to autonomy, I can keep out a woman from a temple? No answer, did not address the question. He did not address the question which is specifically before you. He put it vaguely under the question, I have autonomy. Hands off. That's it. So, my lord, I personally believe you may accept it, you may not accept it. I personally believe this litigation is surrogate litigation for some other outcome which is intended to be achieved by this opinion. That's my belief. Because it covers much more than these 3 issues, the arguments. So, my lord, having said that, I wish now to come back to why am I saying that at this point, my lord, your lordship can now turn to my written arguments. I've given them. But this will be the trajectory of the argument. And my lord, all these issues whether constitutional morality is a ground for striking down, they are bogies. Why? Because no court has struck down anything on the ground of constitutional morality. They have used it to interpret the content of 14, 15, 25, and 26. Not a single judgment they can point to, which actually uses constitutional morality to strike down a law. All right, don't call it constitutional morality, call it constitutional legitimacy. This court has used that expression also in another judgment. So, my lord, I don't want to address bogies. I want to address the substance of the matter. And the substance of the matter is whether Article 25(1) is subject to the right to equality, whether they're bound in law to where any denomination is bound in law to respect equality or not. We must have a straight answer. It's illustrative of what is to come in the future. There will be many, many cases coming before you which will make this demand. People who come after me will be making this demand. The Catholic Church has allowed women to become priests. These are not new issues that I'm raising in this court. At the moment, I'm only raising the issue of entry into a temple for the purpose of worship. I make bold to say it is a fundamental right guaranteed to me under Article 25(1). This is my first submission. The right to enter a temple, a place of worship, is a right guaranteed under 25(1). That's why what is the width and breadth of Article 25? Let us know.
So are you then making a submission that irrespective of any age group I belong to,
Yes.
my entry being woman cannot be restricted?
Yes.
I may belonging to any age group.
The limitation was Hindu. In all the statutes, the limitation is Hindu.
Yes.
But in Sabarimala, they go further and they say we allow Muslims, we allow Christians, but not women, Hindu women. One step further. Of course, 10 to 50, but 10 to 15 is what my 50 is what my productive life is about. That's when I'm really fully alive.
But madam, if there is an intersectional exclusion, can you say that the exclusion is gender specific?
One. The answer to that is I'm claiming both my right to non-discrimination based on gender and my right to enter on behalf as being a secular. I'm claiming both rights.
You are not being prohibited to enter as a woman.
Now,
You are being prohibited to enter as a age band
yes,
amongst women.
yes,
So there is an intersectional exclusion.
yes,
And in
but the
this
law
situation-
addresses intersectional exclusions. It does. The law declared by this court addresses intersectional inclusions because they say we don't bother about your intention, we bother about the outcome. That is the law declared right from Maneka Gandhi, R.C. Cooper till today. Not a single court has differed with that. What is the outcome of it? The outcome of it is I'm excluded. I get excluded on both grounds and I'm claiming both rights.
Who is claiming this right? He is a devotee claiming the right or a non-devotee? At whose instance? A person who has nothing to do with this temple is somewhere in North India. This temple is in South India. Is claiming a right of entry. That also has to be addressed.
I will address that also. Of course, my
Because you
brief.
have to rightly said it can't be.
Religion, integral identity of the religion is not being eroded. At the same time, there is an expression of either Article 19, 21 or 14 rights.
Yes.
In this situation, although we are not deciding Sabarimala, but let us say an example of this nature where 26 definitely trumps 25. It would be required for the court to examine whether 26 is of such exclusionary nature that it completely dims out 14, 19 or 21.
Yes, your lordship will decide that
It be
issue.
an harmonious blend.
Yes, that issue
Why-
will have to be
why
decided.
26 be followed out,
Yes,
as has been held in Saidna and others. We
Well,
cannot follow out a belief, irrespective of its nature of constitutional tests. We need not go into a constitutional test as to how a religion or a denomination will manage its affairs. And in doing that, if the denomination A, we have to, in these facts,
Yes,
decide whether
I
it
want to
is a
make something
denomination
very-
or not,
yes, my lord.
has a certain set of rules.
Yes. Well, I want to make
Madam.
one thing very clear.
One thing. Is it your then submission that this intersectional exclusion itself is impermissible either rationally or constitutionally?
Yes, it is. It is. It is my submission. And but I want to make something I wanted to say. I want to make it very clear. I'm supporting Shururmat. It's rightly decided. I'm supporting Devaru. It's been rightly decided. There is no way you can get out of these two judgments if you want to balance rights. If you don't want to balance rights, if you want one to trump the other, go ahead and do it. Then decide which one trumps which one. But these judgments are giving you, these are the only, where is that? He told me, Milord, there is Justice Mukherjee here somewhere. Yeah. I was talking to Jaideep Gupta, who has changed his stand after the new government or whatever election. We are waiting for election results. But never mind, my lord. He is the one who pointed out to me that this worthy man is looking at you,
He's
watching what's going on in this
also
courtroom.
Justice Gajendra Gadkar. Don't forget him.
Yes. Yeah, my lord. Much has been said about.
Some of them are invisible, but our belief is that they are also looking towards us.
Yes, yes. But the fact remains, jokes apart, the facts remain that his is the only authoritative text today. The Tagore law lectures, if you can get me a better one, I'm willing to jettison this. But the Tagore law lectures on the law relating to Hindu and religious and charitable endowments, there's no better book in the country today. So, my lord, before deciding this case, kindly send for the book from your library and have a look at it. Because we're.
And Miss Jessing, you would definitely be knowing an American judge, Justice Douglas, came to Calcutta and delivered the Tagore Law lecture,
Yes.
titled From Marshall to Mukherjee.
Yes. It's a published lecture. Yeah, and available.
Marshall is the fourth Chief Justice of the United States.
Yes.
John Marshall.
Yes, my lord. That is where judicial review began. So let me say Marbury versus Madison. Lord, we are back after 1 century, 2 centuries. We are back to Marbury versus Madison. Why? I want to know why. Well, Lord, the attack of the other side, I will use a better word, a criticism of the other side, it's really questioning judicial review. That question is the most important question in these 7 questions. Please answer it. Are we being told that religion is hands off from this court? My answer is no. And I give you the reason why. India has a single set of courts. We do not have a separate set of ecclesiastical courts. Therefore, the Supreme Court has inherited ecclesiastical jurisdiction, but the Indian courts have had over the last 2 centuries. 1772 is when it began with Warren Hastings' proclamation, when he said that Hindus will be governed by Hindu law, Muslims will be governed by Muslim law. How is a dispute to be decided?
Jessing, if we have understood the submission, particularly of the Solicitor General and others, it's not a question of non-justiciability, but a question of deference. As in economic policies, so in matters of religion,
Yes.
courts will,
In other
as they say,
In other words, discretion.
fools rush where angels fear to tread.
In other words, discretion.
So we would
Discretion. In other words,
definitely not render ourselves foolish by
let
treading
us
in
not-
areas.
I'm
which
not
are
getting carried away by the
exclusive.
words of the other side, but I've understood the question. I submit, my lord, with respect, I don't agree with this proposition. There is a direct attack on the right of judicial review. That is why you framed a question there. That question has to be answered. And he said, you have no power to decide. You don't have the competence. You don't have the power to decide what is the question of religion. How are you going to decide this case? That was the argument. In black and white, it's in writing. I say, yes, you have the jurisdiction. One answer was given by Justice Bagchi when he said, you can take expert evidence. Courts in India have been taking expert evidence for the last 200 years. Since 1772, when the Warren Hastings proclamation was filed, and those judges did not know how to decide a question of religious right. Every case they're relying on is decided before the Constitution of India came in. Who decided whether an idol has a juristic personality? Is that a question of religion or not? Who decided it? An ordinary civil court decided it in India. And today they're telling you can't decide it.
So if a person aggrieved comes, courts will definitely decide.
Yes, so,
Not
yes, so you,
persons who are not aggrieved who come and ask to decide.
that is on the locus issue. We'll come to that also.
Yes.
I'm on the jurisdiction issue. I'm on Marbury versus Madison. I'm on Article 226 and 32 of the Constitution of India. And let us also clear this confusion about whether I go for a civil suit or whether I go under 226 and 32. This question has also been raised. If there are disputed questions of fact, yes, Section 9 of the Civil Procedure Code will entertain any suit, regardless of whether it raises a religious question or not. They will entertain the suit, and they have been entertaining it. But if I'm challenging the validity of a statute,
Most of the civil court, they are very plenary in nature.
Yes.
So anything it can be decided.
judgments of the court say this.
Section 9 of the CPC is always there. You should be respectful.
It is there in the CPC, which is continued. The CPC, the Civil Procedure Code, has not been reenacted. It continues in full force and effect. It's protected by 372 of the Constitution of India. Law in force. Before the Constitution came. You know, the whole of tort law in India is what? It's the common law. There's no codified law. How do courts decide? So if your religious practice is not codified, if it's a practice, if it's a usage, what stops you from going into the question whether this will get the protection of the Constitution or not? Nothing. So some of these petitions have come before you by way of challenge to statutes. You have entertained petitions under 226 and 32 to decide constitutional validity. When you find that you have disputed questions of fact which you cannot decide, you may relegate the person to a suit. It's a different matter altogether. And one more issue, Section 92 of the CPC empowers the civil court to frame a scheme for religious and charitable endowments. And they have been doing it. So where are we on this question of judicial review which has been framed? The question is not judicial review by this court or by a civil court. A civil court can also go into it, can frame a scheme on how to run a religious and charitable endowment. Well, I'll substantiate it a little more now. I'm just telling you.
Nobody is saying, see, judicial review is a part of the basic structure. Nobody is trying to curtail that.
I
And
understand.
neither do we want to curtail our powers. The question is of entertainability and answering on merits certain aspects of the dispute.
Certainly, Milan, every day I've been sitting in this court. Every day the learned Chief Justice has been saying, why aren't you going, for example, 32? Although Ambedkar said it is the heart and soul of the Constitution, why did he say it? Not because he wanted everybody to come here, but because judicial review is the heart of the Constitution. He didn't say that all of you come running under 32. No. That is the reason why the learned Chief Justice, every time I've been in this court, he said, why are you diminishing the powers of the high courts? Go there. 226 is there. They're co-equal powers, and there are judgments of this court which say that 226 powers are beyond 32 powers. There are judgments of this court. So, my lord, what is the question we are deciding? First, I would like your lordships to decide what is it that you're going to decide in these proceedings, and go ahead and decide it. So, my lord, I understand discretion not to entertain a particular petition is a different matter from lack of jurisdiction. What was said is, you cannot decide questions of religion because you are not theologians. This is the argument I have to meet. If you're not a theologian, call a theologian to advise you. Because religion, what constitutes religion is a question of fact. It is not, or it may be a question of fact and law mixed. But how do you decide religion? It is written down. You have the Quran. Are you going to say that is not religion? You have Shastras to tell you what is religion.
No, the question is whether the court can sit in judgment over conscience.
Nobody wants that. We don't want conscience.
Whether the court can sit in judgment over conscience.
Let me just make one submission on conscience, because questions were asked, how do you distinguish conscience from practice, or from religion? There is a dissenting judgment in the Saidna's case, where the dissenting judge, Justice Sinha, tells us what is conscience, and I'll point that out to you. He says, no one can be called to the bar to account for their conscience. That is conscience. Conscience is beyond calling me to the bar and telling me, why do you hold this view? And I'm not questioning. I'm not questioning that they hold a particular view. I'm questioning a practice. There is still a difference between holding a point of view and practicing. Big difference, not just a difference. I don't question their faith. You hold that view, I'm not stopping you. But in exercise of that view, when you violate my right, I have a right to come to you and tell you, don't allow them to violate my right by way of a practice. These two have to be dealt with separately. So, conscience, that is the reason why in India, I think universal jurisdiction, universal question of law. There's nothing called a thought crime. Crime does not address my conscience, does it? I can be sitting in my home and thinking, I wish XYZ was dead. Can you file a suit against, can you file a criminal case against me? You can't. Because what I think is not criminal. When I execute it, then it becomes a criminal act, as declared by law. In criminal law, you have a distinction between intention and motive, etc., etc. We don't want to go into all of that. Jurists have argued that why are you making this distinction between motive and law, even motive and intention, when you're coming into the realm of criminal law. But that's a big debate, which I don't want to get into. You don't need to, but it tells you the difference between conscience and practice. There is a difference. The two rights are not the same. Now, let's come straight, my lord, to the question, what is the nature of the right? First proposition is, if you open Article 25, it's not a right, it's a freedom. Let us be very clear about it. See the heading. It's a freedom. So, my lord, it's a freedom in the sense that I'm free to do what I want to do, provided I'm not violating morality, health, public order, and other provisions of Part 3. I'm free. So therefore, when I enter a temple as a woman, you have to show me which of these I have violated, because I have that freedom. And that is why I'm saying that the right of temple entry into a public temple, I'm clear, I'm not asking for a right in a private temple. It's a fundamental right guaranteed by Article 25(1) of the Constitution. Law or no law, that right is guaranteed to me by the Constitution itself. Now, we come to 25(2). In fact, in Devaru, if I'm not mistaken, this court has said 25(2) controls 25(1) and 26(b). Both. It is not as if 25(1) is not controlled. It is also controlled by 25(2). For want of a better word, my lord, I will call 25(2) the hero of these two rights. Because it controls both. It controls 25(1) and it controls 26(b). Now, my lord, I was a bit taken aback when I heard suggestions which agree with this proposition, namely that 25(2)b overrides 26. Submissions were made on the other side by some of the counsel. They didn't give it the reason why. Why? Why does it override 26(b)? People have been economical with their submissions, I would say. I won't say economical with the truth. Half sentences. Submissions have been made in half sentences. The logical conclusion of saying that is not drawn. If they agree that 25(2) controls 25(1), what prevents me from entering a temple as a woman? He said it. Mr. Gopal Subramaniam said it, my lord. I have been really enlightened by by listening to so many people who know a lot more about religion than I do. But then reach the logical conclusion of your submission. It is not done. Why? Why are we playing hide and seek with this court? So, I just want, my role here is to just say, according to me, what is the clarity on the questions that are to be decided by this court. That's all. Decision is a different issue altogether. So for that, what is the key to that? The key to that is understanding what exactly is the right to religion. What is it? What is the content of that right? Now that you can discover, as I said. One is, of course, your conscience between you and yourself. You need not go to a temple at all. If you don't want to go to a temple, it doesn't mean you're irreligious. It doesn't mean you're not a Hindu. But if you wish to go, then your right is protected under 25(1). That is a submission I'm making. Why? Because I'm addressing you on what is this right. So now let us understand what is this right. This has always been a civil right. And it's a right in rem. There's no magic about this right. It's a civil right. Somebody did mention it's a right in rem. I agree. It's a right in rem. But what is the meaning of a right in rem? A right in rem determines my status. Just as marriage determines my status. So if I say I'm a Hindu, it determines my status in law. If I say I'm a Muslim, it determines my status in law. So then the question becomes, this is the nature of my right. What prevents you from saying that this status right of mine cannot be violated by another person who's also claiming a right under 25(1)? Whatever be the nature of the right. We are two of us, both of us are claiming a status right under 25(1). They are claiming a status right. Why did Devaru come about? Because both were claiming a right to religion. Both. The denomination as well as the individual. So how to decide the question? That's why, my lord, the only way to decide the question. So I agree with all the three propositions. You need an essential practice test to resolve this tension. Without the test, what are they telling you to replace it? My bona fide belief. Who's going to sit in judgment over your bona fide belief? Please have it.
Madam, Devadu was not dealing with 25(1) versus 26. Devadu was dealing with 25(2)(b).
Yes.
A legislation,
Yes.
and social reform
Yes.
versus 25(20).
Yes.
So
I stand corrected.
there is a very, very thin difference between the two.
Yes.
A social reform making an inroad into the freedoms,
Yes.
be it individual or be it collective,
Yes.
requires an interface which the courts would naturally decide
Yes.
with regard to proportionality and other tests as Devaru harmoniously construed.
No, with respect, I agree.
And when it comes to a situation where it's not a question of the state making an intervention, but an individual asserting practice rights versus the collective asserting matters of religious affairs.
Yes.
In
But-
our understanding,
Yes.
26, by the plain reading of the Constitution, prevails over 25 individuals.
But that is what Devaru does not accept, and I'll explain why. Because both are, I'm now on the question of what is the nature of the right claimed by both. Both are claiming in essence a right to religion. Am I right there? Both. So whether you're claiming it under 25(2)(b) or 25(1), it's the same thing. You're claiming a right to religion.
25(2)(b), madam, is claiming the state power to
Yes.
interfere in religion.
Yes, yes.
25(1) is claiming a individual right
Yes.
which needs to acknowledge
Yes.
and tolerate the other individual rights.
Yes, my
of
lord.
individuals. And there your point is very well taken, that one cannot be ignored in preference of the other. But what happens when that individual right is pitted against a group right?
I'll answer that. But first, let me give you the sequitur of what was just put to me. My lord put it to me that the state is claiming to make an inroad via a law. But the state is claiming it on whose behalf? On my behalf. The state is not claiming it on its own behalf. The state is executing the constitutional mandate. It's respecting, protecting, and it's obliged to protect my rights. The state is obliged, it's not protecting its own right. What are these entry laws? These entry laws are made for me. So they're acting in parents' patria capacity to protect the rights of individuals. And therefore, my lord, that distinction doesn't hold when it comes to deciding how to harmonize. So the only way to do it is to harmonize. Now, the other side is telling you, throw away the essential, throw away the essential practice test, throw away Devaru, throw away Shururmat, make everything and everyone a denomination. I, Indira Jaisingh, say I'm a denomination. Why not?
See, freedom of conscience was not given to us on January 26, 1950.
Yes.
That is something which man, civilization has, with the evolution of the spiritual aspect of man, through the passage of, you see, years and years and years, it is something which has been evolving. Constitutionally, it has been circumscribed by certain aspects. Now, the question is, what has been evolved by man over the civilizations? How much of that has to be protected? And at the same time, protection of that, how far it will sort of inroad into the other aspects which are the riders for that freedom. That is the whole essence of this debate.
It is true.
Now, it's not that we got a freedom of conscience only on 26th of January 1950.
Yes.
It has been there for ages.
Yes.
So, but that freedom, how far constitutionally we have to curtail, that is the only aspect which has to be considered.
That's right. That's why I
Now,
said.
what has been developed over the ages,
No.
what has to be protected, cannot be taken away by the constitution.
Yes.
That is the issue.
Therefore, that is why I said all the 6 questions can be collapsed into one. For a moment, forget the locus. This is the only question to be answered. All 6 questions lead you to this question. What is it that is protected? What is it that is not protected? That is the issue before these 6 questions. Now, will that question be decided on the basis of semantics, as has been suggested by the other side? Or is it going to be decided by the conscience of this court, by the conscience of the Constitution, which some judges have called constitutional legitimacy and others have called constitutional morality? Forget words. How will you decide that question? You, as a constitutional court, also have a conscience. Your conscience is the Constitution of India. So this question will have to be decided with reference to the entire Constitution of India, not by looking only at words in 25 and 26. It's one indivisible constitution. How will you answer these questions? Just by looking at a dictionary and saying, this is how I answer. That is why I said in my written submissions, the first thing I've put down is how do you read a constitutional text? And there, even this court has referred to the proposition you read it as a living document. Forget constitutional morality. What is the meaning of living document? A living document, questions which the framers could not anticipate, you have to answer. And how will you answer questions which the framers did not anticipate? By looking at what? By looking at the Constitution as an organic whole, you will answer that question. This question may not have been in the contemplation. All right, the question I'm raising, though I will tell you it was in the contemplation of the Legislative Assembly, whether women are untouchables within the meaning of 17. I will show you from the debates women are mentioned there. But whether you agree or disagree with that, it's not relevant to the outcome of this case. Article 17 is an additional argument. But the crux of it is this: who to exclude, who to include. This is the question. How far will your conscience take you? Will it allow you to do a practice which excludes another person who has a right under this very Constitution? Does it allow you to exclude a practice? That is why I said, okay, conscience is fine, my lord. Nobody, I'm not questioning their belief. Maybe a Naistic brahmachari may not be. I don't say it's not. I don't say it's not genuine. I don't say it is not bona fide. But I do say these are not the tests evolved by this court. This court evolved the test of essential practice. Because it is not a subjective test. That is why this test was evolved. Genuine is a subjective test. Are you going to sit in judgment over the genuineness? I don't sit in judgment over it. Are you going to sit in judgment over their bona fides? I don't. These are the two alternative tests which have been suggested. But this court said, no, to harmonize the rights, the test is essential religious practice. That is the answer to the question, how far to protect, how far not to protect. A practice. And therefore, please don't throw out of the window the essential practices test, because if you throw it out, then the autonomy argument will prevail.
Can also not ignore the civilizational and religious history of this land
Yes,
while considering this issue. It is
yes.
in that background that these two articles have come about.
It is true, but it is also
Living document, organic, it's good. But let us not forget the
background.
the past. The
Yes.
past makes the present.
Yes.
We can't
Yes.
ignore the past and say there was a vacuum and on a clean slate we started the constitution.
It is a clean
debate.
slate. According to me, it's a clean slate,
Can't
but
be
we
in a
can have a
clean
debate
slate.
on that. We can have a debate on whether I take the view it is a clean slate, but I agree that the background to the drafting, may I just complete? I agree with you that the background to the drafting of 25 and 26 was the existing religions in India. It was. Whatever they may be. It was Hinduism, it was Islam, it was Christianity, it was Judaism, everything. That was the background. My Lord, everywhere in the world where I travel, I'm told, wherever I go, there's no other country in the world, no other constitution in the world which protects every religion. None. I challenge my friends on the other side to show me one constitution. Many constitutions have been cited in this court. Show me one constitution which protects all these religions, every religion. So that is background in which these two articles have been drafted. There's none, my lord. I can tell you, international jurists have given opinions on this, that India's constitution is unique. That is why it's called unique. But this is the reason why it's called unique. Because it protects all faiths, and because it also gets rid of all the limitations on the right by rejecting caste, by allowing temple entry, by removing all the disabilities attached to religion. That's the reason why it's considered a unique constitution. No other reason. You think of the consequences of what they're saying. What was the case about? That another Brahmin, except a god Saraswat Brahmin, cannot enter that temple. That was the argument. You want to accept that argument, their argument, what is the consequence? There'll be no temple I will be able to enter. It will be a complete balkanization of Hinduism. Torn to bits. Everyone will say I'm a denomination. Whereas the history that is being told to me is the history of this country, is the unification of the different sectors, sects, call them what you like. Then there's a question which requires to be answered. In that case, why is 26 there? What exactly was the need for 26 in the Constitution of India? It did not have been there. Or you could have had, could you have, okay, let me reverse the question. Can you have only 26 without 25? Is it possible? It's not possible. Then comes the next question, what was the need for 26? That goes back again to the nature of religion in this country. That is the answer to that. Hinduism has been over centuries reforming itself. Religions reform internally. We are told, no, court should not reform religion. But the fact is that every religion reforms itself from within, if it has to survive, and if it has to have any meaning for human beings. And therefore, the history of Hinduism is the history of reform movements within Hinduism. That is why there is a need for denominational protection.
That is different from saying that the court should reform a religion.
It is very different. The court's only recognizing it. You are recognizing that process. Just as I was told that there's a background to these articles, similarly, there's a background to putting denominations there. The background is the background of reform. Tell me one religion which has not reformed. Same with Islam. At least in law school, I studied Muslim law from Faizi. I studied Hindu law from Mullah. So you take any book on Muslim law and Hindu law, you will see a history of reform in it. Because religion has the capacity to regenerate itself, to reinvent itself, if it is going to be relevant to human beings. It is going to have to reform itself. And it has done. And that is why the word social reform is there in 25, where is it? 25 2b. These three go together. Social welfare, social reform, and throwing open Hindu Hindu institutions, religious institutions of a public character. The three go together. Reform of religion is social reform. What else is it? Are you reforming the economy? Are you reforming finance? Are you reforming a secular matter? No, you're reforming religion. And what's his name? I think Mr. Dhawan is there. Yes, he said, I'm an Arya Samaji. Yes, he is an Arya Samaji. He said it. He said it. But what he didn't tell you is that Arya Samaj does not believe in the sanctity of the Vedas. So there are changes. This is why a denomination must have a doctrinal change. There has to be something doctrinal in it to be a denomination. You can't say I'm a temple, so I'm a denomination.
Hey, madam, what is unique in India is diversity is our strength. And what section Article 26B does is to recognize the diversity. We are strong because we are diverse. And diversity is our strength. And to bring about a recognition of that diversity in denominations, Article 26B protects it. By giving such a protection, there is a unity also developed in the country. That is how we should look at it.
Yes, it is unity and integrity of the nation. Not only your doctrinal differences will be protected,
Therefore,
but your interreligious differences are also protected.
Therefore, respect diversity.
Yes, respect it, but show that you're diverse. Don't show me that I'm a temple and that therefore I'm diverse. Show me your diversity, no? Every single, I want to make one observation, and if I'm wrong, your lordships may correct me. In the 75-year history of this court, the only institutions